sense from reading your briefs, but I think there are some additional things that you raise as well. Anything you would like to say here today to supplement what you've filed or based upon what you've heard here this afternoon?
Sure, Your Honor. I think that most of my points have been covered in written submissions and by the other attorneys that spoke today. But I would like to address just one additional point that I don't believe that the state has responded to either today or in its submissions. And that is that in meeting its burden to show that this regulation is constitutional, the state needs to demonstrate that the compelling interests that are purportedly served by this law are not served equally effectively without the law. And I don't believe that the state has done that. And as you briefly mentioned, and I mentioned in my brief, that we have other laws on the books that would pertain to any of the activity that the state is trying to address with these regulations. We have criminal statutes that govern resisting an officer, and the access policy also allows the police to ask people to leave when an event is disruptive. And we have disorderly conduct, as you know, which is very broadly drafted to cover most disruptive activities. So I would like to hear the state's position about why this regulation is constitutional with that in mind.
Well, what about this idea, though, Ms. Curl, that in addition to the disorderly conduct aspects, the presence of more people implies a greater level of noise. And we heard that briefly alluded to this afternoon, that was an issue that they looked at and apparently recently did some type of study on, although we don't have it here. I think you'd acknowledge that that is a concern. And so the permitting requirement might address that concern, assuming that it was targeted at a high enough floor, which is Judge Conley's point, in a way that the disorderly conduct ordinances and statute might not necessarily get to. In other words, just by dint, as Judge Conley says, of numbers, the situation could reach a level where it would be reasonable to say that the state should or could require a permit, but there's still not any individual actor who is acting in a disorderly way. Does that make sense?
Yes, Your Honor, and I believe there is a provision in the access policy that does cover that, and it's in my brief. I believe that if there's an event that is excessively noisy or causing any sort of disruption, that Capitol Police are permitted to ask people to leave if something is disruptive. And I don't see how that differs from the situation that this regulation is attempting to prevent.
Ms. Weezy, any particular response?
I have nothing beyond what was written, what was submitted in writing.
Okay, all right. Ms. Curl, anything further than this?
Nothing further, Your Honor.
Okay, well, thank you again for your written submissions and for your argument today. And you and Ms. Nash may certainly be seated.
Thank you.